Welcome everybody to our 22nd episode of our Bay Area Housing Market Town Hall. And today we have our guest speaker, Sarah Kern, who is going to talk to us about how to hold title the right way so you can best protect yourselves as investors or as a homeowner. So let's get started. I actually just came back from vacation last night. And I know a lot of people have gone on vacation, and I was rushing out my presentation today because in my mind I kept thinking about I really want to share with you guys regarding this inflation talk that we've been hearing. So I'm really excited, and I do have a lot of information I want to share because we want to provide education to you and also our real estate industry so that we can empower each other to help each other out to make sure that you guys have the right information to be part of this real estate investments journey. So today we have Sarah Kern. She's an attorney and partner at Lerman Law Partners. And we had Jeff Lerman speak at our webinar before, and Sarah works with him. And she specializes in estate planning, trust administration, and probate. And her practice focuses on helping parents, individuals, business owner, and same-sex couples pass on their wealth in a tax-efficient manner that avoids the time and expense of probate. She also assists in the distribution and administration of assets after death, guiding her clients to minimize their stress. She uses her years of experience to custom design trust, wills, durable power of attorneys, healthcare directives, and other estate planning documents. So I want to welcome Sarah to our webinar and talk to us a little bit more about how we can use different titles to best protect themselves. Especially, I had talked to Sarah before that quite a few of our investors just really want to protect their privacy, especially when they own an investment property. Hi, Sarah.
Hi there. Hi, nice to be here today. Thank you so much for the opportunity to speak and share some insights about estate planning focused on real estate investors. So I really appreciate that. Thank you. So good afternoon, everyone. My name is Sarah Kern. I am a partner at Lerman Law Partners. We are an estate planning and real estate boutique firm. We are known as the real estate investors firm. So we are really focused on that special synergy that happens between real estate investors and just regular individuals who want to make sure that they're handling all of their estate planning needs. My feeling is that, there are some things about being a real estate investor that need to be really carefully synced up with your estate plan. There can be real property tax reassessment consequences. There are some important consequences in terms of, how you're structuring assets for creditor protection. So having, working with a team that's integrated and ready to work together is really an advantage. So the slide I'm showing you right now is an attempt to show you my law partners, Michelle Lerman and Dylan Recht, both of whom are also estate planning attorneys, and we work really collaboratively together. I am, this is me and a little bit about me. I am a Bay Area native. I'm actually a fourth generation Bay Area native. I earned my law degree at USF in San Francisco. So I'm very happy and proud about that. And what I also want to say before we really get started and dive in is just a reminder that all of the comments I'm sharing today are intended for general informational purposes. But before you act on any of the ideas that I share, it's really important that you speak with your estate planning attorney and your other legal advisors to make sure that any strategy that you're considering is really appropriate to your particular circumstances. So let's dive in. Benjamin Franklin was known to have said, "In this world, nothing can be certain except for death and taxes." And if that leaves you feeling a little bit like this, I understand, and I'm here to help. I realize that estate taxes and recent changes in federal tax law, all of this stuff might be frightening, might be overwhelming, may not be your favorite subject. You may have a lot of questions. Do I need a living trust? What's changed in the law? What's going to happen now that we have the Biden administration and a new Congress? How can I best protect myself and my heirs? And that's my goal to address in this presentation, get some of those questions settled. So what we're going to cover, I'm going to share with you the current status. What does the current but temporary Tax Act say? what changes are expected under the Biden administration, and some special concerns focused on the interests of real estate investors. So hopefully you can see at least some of the information on the slides. Helen, maybe give me feedback if a particular slide is really causing a problem. In terms of the Temporary Tax Act, where we are right now is, one of the things that attorneys need to take into consideration as they're doing estate tax planning is they need to think about what is the estate tax itself, what tax applies. So in California, there is no estate tax. And I always like to stop and enjoy that for a moment because, as Helen mentioned earlier, this is a really tax heavy state, but there is no tax owed to the state at the time of your death if you're a resident when you're of the state when you die. There is, however, a federal estate tax. And there's also a federal estate tax exemption amount. So that's the amount that any individual can give to others before estate tax applies. And Congress is the body that controls what the estate tax exemption amount is. Right now, we're operating under two separate laws passed in 2 different years that combine together to give us an exemption amount of $11.7 million free of transfer tax. The way that worked was that we had the American Taxpayer Relief Act of 2012. That act set the base estate tax exemption amount at $5 million, but included an inflation adjustment. And it also set the rate for estate tax at 40%. And that's a fairly low estate tax rate, historically speaking. So that had been the law since 2012. However, at the very end of 2017, a new law was passed that took effect in 2018 called the Tax Cuts and Jobs Act of 2017. And that act made a few changes that applied to the estate tax world. So one of those changes is that the estate tax exemption amount was temporarily doubled. And that's how we get from a $5 million base amount to a current $11.7 million of estate tax exemptions for deaths occurring in 2021. The tax rate itself remained unchanged at 40%. And that modification, I mentioned it's temporary. It's in place from 2018 through the end of 2025. Just to give you a point of comparison so you can measure for yourself how unusual the circumstances are that we're in right now. 20 years ago, in 2001, the estate tax exemption amount at that time was $675,000. That meant that was the amount you could leave to another person, and every dollar after that was going to be taxed. And the tax rate was higher. The tax rate at the time was 55%. So you were going to pay 55% of every dollar over $675,000. So where we are right now, comparatively speaking, it's just a much, much larger amount of assets that can be passed to your family members at your death. And one other important note is that we have right now what's called a unified estate tax exemption system. And what that means is that the amount that you can give at your death is the same as what you can give during lifetime. In other words, if I decided to, and if I had the assets, I could give 11.7 million of assets right now using up all of my exemption amount, or I could wait and hold on to the assets and then give them at the time of my death, or I could split the difference and do a little bit of both. One other thing I want to draw to your attention is that outside the scheme of the estate tax exemption amount, there's also in the tax code the ability to make gifts on an annual basis that don't count against, they don't use up part of your lifetime gift or exemption or your estate tax exemption amount. So right now under current law, we each have the ability to give $15,000 per year to as many different individuals as you want. So if you were a married person and you have 2 adult children and 5 grandchildren, you could actually give away more than $200,000 per year without consuming any of your estate tax exemption amount. And not only that, but you're going to get all of those assets plus all the appreciation on those assets out of your estate forever. No gift taxes required and no tax is required at the time. So that's a really important thing for people to keep in mind in terms of the strategy of moving assets out of their estate, their taxable estate. And just the last thing I want to remind everyone is that this is a temporary act. We know if Congress doesn't take additional action that this law will expire at the end of 2025. But having mentioned Congress taking additional action, that brings me to my next slide. There have been proposals under the Biden administration and our new Congress that are going to potentially radically change the whole estate tax regime and do it sooner than 2025. We don't know precisely when this legislation will pass or if it will pass, but if it does, it's going to make some pretty significant changes. So there's a few things I want to call out to your attention. First, there has been talk that this legislation might pass at the end of this calendar year, but be retroactive to the beginning of the year. So this is a real time of uncertainty in terms of estate planning. It means that clients are aware that things are changing. They want to take action. They obviously want to take advantage of that extremely high estate tax exemption amount I was just mentioning, but they don't know if they make a move now, if they're going to essentially be penalized when by the end of the year, the laws governing what is an acceptable gift in 2021 may have shifted. So it's really kind of challenging and takes a very nuanced approach to determine what's a good move for any individual's specific set of circumstances. So some of the things that are on the table in terms of potential changes, one is there's a proposal to lower the estate tax exemption amount. It sounds like right now the target number is 3.5 million per person, so that'll be 7 million for a married couple, and that's in comparison to our existing 11.7 per individual and 23.4 million for a married couple. There's also talk about lowering the federal gift tax exemption for lifetime gifts even further, so bringing it down to 1 million. And that's really going to shift the strategies that are available for what we'd call advanced planning. In other words, if you want to make a gift during your lifetime, you're going to have only $1 million worth of assets you can give while you're living. And that just means that there's going to be more tax realized at your death when the estate tax comes due. In addition, we're looking at potentially, potentially increasing the estate tax rate. That's certainly on the table. And then another important detail is a potential shift in how capital gains are treated. So right now, one of the really important benefits that federal tax law offers us is that when a person dies, all the assets that are in that person's taxable estate receive a basis adjustment for income tax purposes. So obviously, if you've purchased an asset like a piece of real estate a long time ago, it has a very low cost basis, you've held it for a long time, it's really appreciated and it's worth it a lot more now, it becomes kind of problematic. You can't depreciate that asset any further. If you sell it, you're going to have to deal with recognizing all of that gain. And people end up kind of locked into holding pieces of real estate that they maybe don't even really want to have any longer. One advantage for your family, obviously, it's not a personal advantage, but at your death, any asset that you own that's included in your taxable estate, it receives a basis adjustment so that its new tax basis value is whatever it happened to be on the day of your death. And that means that if a surviving spouse or if a child or another family member is to sell that asset after your passing, the capital gains may be zero or they're substantially reduced from what they would have been. Well, it's on the table that whole regime may go out the window, and that what will be replacing it will be the concept of a carryover basis rule. In other words, if I bought a piece of real estate 20 years ago and I paid $100,000 for it, and I leave it to my child at my death, her basis will be $100,000 in the asset. And it doesn't matter what amount of appreciation is built in. So if and when she goes to sell it, she's going to have to deal with all that gain. The other proposal on the table is to treat death as a recognition event. And what that potentially means is that in addition to dealing with estate tax at the time of your passing, your family members may be paying income tax on gain that's, an appreciation that's built in and hasn't yet been taxed. So some really significant changes potentially coming there. Having said all of that, I want to take one step back and I want to focus on what do we need to do kind of at a base level to get started on protecting ourselves. And what I think we all know, we've heard this before, some of us have acted on it and some of us haven't, is that sooner or later you're going to need a proper estate plan. Your estate plan should be taking into consideration a number of really important details: your specific assets, your goals, your family, the tax laws, the potential change in tax laws. There's a lot that goes into it. But the list of documents here is a really important starting point. And it starts with a living trust, a revocable living trust, which is basically designed to ensure that no probate proceeding is going to be required at the time of your passing. Most of our clients want to avoid a probate proceeding. And a probate proceeding, by the way, is a proceeding that happens in a probate court, which handles the affairs of individuals. And they can come up, probate proceedings can come up if you're either alive but incapacitated and someone else has to be placed in charge to be able to make decisions for you, or at the time of your death, if you have no estate plan at all, or if your estate plan consists only of a will. So as a way of helping understand why people want to do estate planning and avoid a probate proceedings are really long and slow. They're always happening at a time of enormous stress for a family because you've just gone through an accident or an illness or a death, and that added stress is just really unnecessary. Probate proceedings are really expensive. They're based on the gross value of the assets passing through a probate estate. So for real estate investors, you may be very leveraged. The total gross value of your assets may be a really large number. I'll give you just a small example. If you have a gross estate of $1 million, no matter how much debt is there, the fees to the attorney are going to be $23,000, and the fees to the person serving as the personal representative are going to be $23,000. So that makes estate planning look like a real bargain in comparison. They're public proceedings. I think most of us would rather have, keep all of our information private to the extent they can. And importantly, you lack control in a probate proceeding. So the judge is going to apply defaults under California law to your situation, and that may or may not align with what you would have chosen for yourself. So how do you avoid a probate proceeding? You prepare an estate plan. And basically, that's a set of legal documents. It's designed to anticipate the situations where a probate would be required, and it places another set of instructions in place so that a probate can be avoided. So that's the basic, that's our goal here. So I want to tell you about a critical next step for those of you who either already have an estate plan, or for those of you who just realized you need one after listening to what I just shared. So for married couples, the really critical issue is, how is your trust set up? What does it instruct should happen when one spouse has died? Does it require all the assets to go to the survivor, or does it require the assets to split into two separate subtrusts? So the first trust structure that I'll mention is what we call an all-to-spouse trust. It's also referred to as a power of appointment trust. And with this trust structure, essentially the first spouse to die leaves everything to the survivor, and the surviving spouse has complete flexibility and control over those assets and can change the trust terms, including changing the beneficiaries or changing the trustees. And this can be a really good approach. It's very simple. It can be a good approach for a modest sized estate, or for a couple that have been together for a really long time and their wishes and values are really well aligned and there's no worry about that. But this trust structure doesn't really offer much in the way of, in fact, it doesn't offer anything in the way of creditor protection. And it doesn't offer a lot of certainty and control over what's going to happen to assets once the surviving spouse dies. So that flexibility is both the strength and the weakness with this plan, if you will. It's appropriate for some situations, but not appropriate for all. As an alternative, another trust structure that will provide for the surviving spouse, but which has a lot more certainty and control and some really nice benefits for the surviving spouse, is a split trust, or an AB trust. Those are interchangeable terms. So with this split trust structure, all the assets start in one bucket together while both spouses are still living. That's called the living trust. You'll see that at the top. And then when the first death occurs, the assets get divided into two separate subtrusts. One part holds the assets of the surviving spouse, and that part stays fully flexible and fully revocable, which I think makes intuitive sense because the surviving spouse is still living. He or she should be able to use those assets however they want to. then the other portion of assets passes into an irrevocable trust for the benefit of the survivor. And those assets are receive creditor protection while they are in trust. So that's a really important benefit. When you create a trust for the benefit of another person, you can create some creditor protection. So it's better protection than what you can create for yourself. And they also, we can limit the right of the surviving spouse to change who receives assets from the protection trust following the survivor's death. So the surviving spouse has the first spouse to die, excuse me, has a little bit more certainty and control over what happens with part of the assets following the second spouse's death. And there's one other thing I want to mention here. There are some really important provisions that each one of us should make sure is in our trust if we're using this AB trust structure. And that is that we want that B trust, the part holding the assets that belong to the first spouse to die, to have provisions that permit the surviving spouse to make the Q-tip election. Now that's a tax election, excuse me, that's a tax election that that allows the surviving spouse to take some or all of the assets of the B trust into his or her estate for estate tax purposes, with the benefit of getting a step up in basis for income tax purposes. So what this essentially does is it lets us make a plan now that's protective, and then it gives us a second bite at the apple in terms of doing tax planning following the first death, to try to achieve the best possible tax result. So if after the first death, we look at all the facts and circumstances, and it's our belief that no estate tax is ever going to be owed, then we want to start worrying about the income taxes. And that's where the surviving spouse is going to make that Q-tip election.
Sarah,
So
can I ask a question?
Absolutely.
Wondering, so with this living trust,
Mhm.
I think we've talked about this on the phone as well. Some of our clients who want to maintain their privacy, they would, instead of having their names as a trustee, they want to
Yeah.
use a company or maybe another trust to hide their name. So a second layer,
Yeah.
will that affect this structure?
Yeah, so I will, if you don't mind for a moment, I'm going to just put that on pause. I actually am getting to that in another slide. It would slightly affect this structure, is the answer to your question. It's actually going to end up with a trust nested inside a trust. And so I'll give you a little bit more detail in a minute. Thanks for that question. So in terms of just a final word of warning on this split trust, some of the people here today probably have a trust structure that includes what we call a traditional bypass trust. And what that means is it doesn't have that special set of provisions that make it possible for the surviving spouse to make a Q-tip election. And I just want to mention that can be a potential tax trap, producing a really negative income tax consequence if it turns out that that no estate tax is going to be owed. So that's something that you should each do today or in the near future with your estate planning attorney. Review your existing trust, make sure that if you do have this split trust structure, you have the right, you've got those Q-tip provisions in that allow for flexible planning in the future. Another thing I wanted to mention is the concept of ongoing trusts that allow you to protect assets. So I know a lot of real estate investors are familiar with the concept of LLCs that help us set up assets in such a way that that we're siloing liability and focusing in on a single group of assets. Trusts can actually be used also to silo liability or to make assets more difficult to reach for creditors. So one thing we want to do in terms of planning is that if you're giving gifts to your children, we want to look at whether it's lifetime gifts or gifts at your death. Potentially we want to create a dynasty trust that holds the assets in trust for your children for the child's entire lifetime, rather than giving them assets outright. That type of planning can have tax benefits down multiple generations, and it also means that the assets your children receive from you receive creditor protection better than what you could purchase for yourself. For example, if a child's marriage later dissolves, the assets that they have inherited from you are not going to be used. They're not going to be divided in the divorce, and they're not going to be used as the basis for a support calculation. So that's a really important strategy. Beyond the lifetime trust for the children, there's a number of different kinds of, interesting and complicated irrevocable trusts. And I'm going to just kind of mention this briefly. We don't have enough time in this session to really go into a lot of detail, but this is something you'll want to dive into with your estate planning attorney in terms of whether any of these strategies are going to be appropriate for you. Using real estate as an asset to gift into an irrevocable trust is really great because we can actually get a valuation discount when you give a portion, but not all of a piece of real estate, or a portion, but not all of a piece of an LLC holding a piece of real estate. So in terms of making gifts now, an advantage of doing that is, the advantages are great. You're getting assets and appreciation out of your estate. You're putting assets into the hands of your children in such a way that they are going to be able to use them and have a really great and productive life. There's protection. There's all these different benefits that are available. But it's important to remember there's a couple of downsides. One of those is any asset you give away now, you're giving away irrevocably. But another downside, and this is just framed from the perspective of your children, is that those assets that are gifted into those irrevocable trusts, they're not going to receive that basis adjustment for income tax purposes at the time of your death. So this brings me to critical step number 2, which is basically funding your trust as a means of avoiding probate. Funding your trust, for those who aren't familiar with the term, is the process of transferring assets into your trust. And Helen, here I'm getting closer to answering your question from a moment ago. So once you've created your trust, that's the first step. That's great. It's a large milestone, but you actually have to go further, and you have to take the assets that are currently titled in your individual name and transfer the title into your trust, so your trust is the owner and the controlling entity for those assets. And in general, you want to transfer everything you own into your trust, with the exception of retirement accounts. Retirement accounts are tax advantaged, and they need to be owned by an individual for tax purposes. So we don't put those into the trust. Your real property can go into the trust directly, or is more commonly the case with real estate investors, it can go into an LLC first and then into the trust. And Helen was asking about what can we do with estate planning in terms of asset protection and privacy. So this is kind of a complicated area of planning. In terms of asset protection, there are some strategies that are available. Creation of an irrevocable trust is one of those, but every time you create an irrevocable trust, you're giving assets away permanently. You lose control, but you lose the ability to dictate what happens with those assets and to enjoy the use of them. There's a variety of different strategies, but one thing that's really important to call out is that each one of these strategies has advantages, but also has potential disadvantages. So some of those are, there's fraudulent transfer laws. Basically what that means is if you are creating trusts or any entities for a business purpose, that's fine. But if you're doing it after an incident has occurred as a way of avoiding coming forward and paying the creditor, that's going to potentially be problematic. Also, some of the structures that are available create a lot of complexity. So other companies and institutions that you're familiar with working with may not be familiar with these entities and structures, and may have, resistance, or may take extra time or extra steps or extra cost. So things like title companies, there might be problems with your title insurance. You might have lenders who aren't willing to work with you and issue a mortgage because they can't tell who's the owner of an asset. And then one final potential issue is if there is litigation around an asset, so if you either want to bring a suit to defend your rights, or if someone is suing you, there can be an added layer of complexity, which means, frankly, just an added layer of cost in terms of trying to figure out who owns what. So one of the, in terms of what options exist, I mentioned already, probate avoidance. That's basically just the creation of a living trust, funding it with your assets. In terms of asset protection, what we're looking at there would be, insurance, appropriate insurance, forming LLCs, as I said earlier, creating an irrevocable trust. And then in terms of asset privacy, and I think this is what you were asking about, Helen, the option exists to create what's called a blind trust. And with a blind trust, what you're doing is you're separating the record title of owner from you. You're using another person to act as the record title of owner. And so what you end up doing is you form a trust that's essentially held, that's separate from but tied to your revocable living trust. You're the settlor of the trust. Someone else whom you've selected serves as trustee, and that person is the record title of owner for your assets. Now that trust remains revocable while you're living. And what that means is you can change it. You can, take assets in or out. You can change the trustee. And it then has an instruction that indicates basically at your death, the asset pours into your revocable living trust in order to be distributed according to your trust terms. I just want to flag that those trusts, blind trusts, are, they're very uncommonly used. They tend to be used more by very high net worth individuals who are really looking for privacy, not so much as a shield against creditors, but to avoid kind of media intrusion into their personal lives. So, authors or musicians or actors or what have you. And I just want to also make sure people know that there's really, potential for complexity here. So we had a client a couple of years ago who placed an asset into such a trust. And then as he needed to refinance, as he needed to do some other things, and he actually ended up needing to initiate a suit related to his real estate. In the end of the day, he ended up having to take the asset out of the real estate because he couldn't get the other institutions he was dealing with to recognize his ownership interest, despite the fact that that trust was revocable. So this is a kind of an area of law in California where there hasn't been a lot of law written. That means there's opportunity, but it also means there's potential risk and there's potential expense.
And Kendrick just asked also, do you know how likely title companies work with blind trust arrangements?
With blind trust, and I'm sorry, just to make sure I heard correctly, did Kendrick ask if there are any that do, or how unlikely it is?
How likely title companies?
Oh, how likely? It's a tough call. I think it's probably possible to find a reputable California title company that would work with a blind trust situation. One other thing, and I don't know if I mentioned this earlier, when you transfer your property into a trust, there is a possibility under existing California case law that title companies may not need to continue to ensure your good title. So prior to transferring any real estate at any time into a trust, you should always check with the title company to make sure that this transfer doesn't void your title. In other words, your title insurance just carries on. So I would say with a blind trust, with formation of a blind trust, first, I think you're going to have a little bit of a longer search, finding a company that is going to work with that and accept that and move forward. And then secondly, I think you need written confirmation that that transferring that asset into that blind trust isn't going to cause a problem with the title insurance.
And I guess like besides title insurance, also have to think about the mortgage side, the mortgage lender, whether they will
exactly
allow that
same thing. If there's potentially could be in violation, trigger a due on sale clause. We certainly wouldn't want that. And always you would just want written confirmation. Starting with a kind of more informal investigation, but definitely having written confirmation before proceeding.
I guess like is in a way is that a lot of these things probably can work. It's just that it is hard to find everything aligned correctly and then make it work, and it probably costs a little bit more time and also money in order to make it work.
Exactly. So the option exists. I think it's very desirable. I don't think I said this out loud. I know it was written somewhere in one of my slides, but I think one of the things that's really important to know is that the state has an interest in seeing that when people suffer an injury, that they are able to have that injury redressed. And so although it is possible to create creditor protection, and it is possible to create privacy, none of that is impenetrable. There, with a court order, you absolutely could be forced to disclose who you are and what your other assets are and so forth. So it really depends on the facts and circumstances of whatever incident is happening. But anyone who tells you that it's going to be impenetrable armor, that's, you shouldn't be talking to that person. That's not good advice.
And you had mentioned a lot about the living trust, and a lot of real estate investors, obviously the first thing they think about is like, oh, I'm going to create an LLC instead of living trust. How can you combine both to create an LLC and the living trust?
Yeah, that's a great question. So they are doing two really separate but important tasks, a living trust and an LLC. The living trust is keeping your assets organized so that someone can step in and use them for your benefit while you're living, and so that there's a clear set of instructions about who's in charge and who receives assets after your death. So that's its job. It's trying to help you avoid probate and organize everything in as tax efficient a manner as we possibly can. The LLC has a totally different task. It's trying to silo liability to a particular investment and maybe the connected bank accounts. Some of our clients tend to group assets together in LLCs related to their liability profile, and some clients are really deliberate about having separate LLCs for each different investment. Either strategy could be appropriate, and you'd want to consult with a professional who would advise you what's the best course of action for you. But once you've formed the LLC and you have an ownership interest, whether you're the sole member or if it's a multi-member, if you own a certain percentage, you want to transfer your ownership interest into your revocable living trust. That's basically done via a document called an assignment of membership interest. It's really short. It essentially expresses your intention to hold title in the trust. You sign it and date it and notarize it, and you're set. And that becomes part of the official records, ownership records of the LLC, membership records of the LLC. And that it's comparable to the steps that you would take if you had a bank account that you wanted to have controlled by the trust. You go to the institution, you have that institution prepare the correct forms to show that, the bank account that holds your money, instead of being in your individual name, it's now going to be titled in your trust. Same idea.
Yeah, that's another extra layer if somebody really wants to be a little bit more anonymous. I don't really want people to know who own this LLC. That's when they can create a living trust underneath. And if this is multiple members, even one of the members, or several of the members can use this strategy as well, correct?
Yeah, you certainly could. I think one other thing that's important to know, in California, you cannot have a corporation serving as a trustee of your trust unless that corporation is a registered trust company. So for example, you can, Wells Fargo Bank has a trust department. You can hire them to be your trustee. Of course, again, we talked earlier about some of the downsides of this approach is cost related. They are certainly going to charge a fee for their services, but they'll be happy to do that for you. But once there's, I'm sorry, I wanted to back up one step. It is not an option to go ahead and name just an LLC directly as a trustee of a blind trust. So I wanted to make sure I called that out because I've certainly heard questions about that before.
Absolutely. I wanted to address a couple questions here on the Q&A box.
Sure.
Somebody had asked, could more people move to an area if offices can now have more part-time in-office workers versus pre-pandemic limited full-time in-office capacity? I mean, it is still possible to have people moving into an area. I think, especially knowing that I assume that you're talking about Bay Area specifically, knowing that a lot of our tech companies are actually expanding here. They probably obviously would be hire more people. I cannot say for sure, but I did hear some of the companies have said that if you don't plan on living here in California, they're going to adjust your salary. So that is going to may have caused some people to decide that maybe I should move back to California. So, I mean, I do think that there are still people who just want to move here because they prefer to live in California for the weather, whatever it is. So yeah, but I don't think that just because they ask for part-time in office workers, because once it's part-time in office, it's going to be really hard for them to say, oh, I'm going to live out of state. I think once it's that, they're going to have to still move back some way, maybe not as close by, but still need to be driving distance away. Okay, so another question is that with regards to investment properties, is there a general rule of thumb that is property value, number of tenants, et cetera, where it makes more sense to own an LLC versus individually with umbrella insurance? That's a great question.
So from my perspective, and I'm not an expert in LLC formation, I just want to make that disclaimer, but from my perspective, this really has to do with isolating liability versus just dollar value or just something like number of tenants or what have you. So anytime you have rental property, you have exposure, or frankly, any real estate, whether it's your rental property or not, you have exposure as a landlord. And if you have multiple different properties, and if I come to one of your properties and I trip on a crack in the sidewalk and sue you, if you are using an umbrella insurance policy strategy, I can gain access to not only the value that you have in the apartment building where I happen to trip and fall, but also to your equity in all your other investments. So if your umbrella insurance falls short of whatever my claim happens to be, you're exposed across all of your investments. Meanwhile, if you had, separate LLCs that were holding, in one case your apartment building, and another case your, single family rental home, or, your commercial real estate, the absolute outside of what I could recover if I were injured at your property would be whatever assets exist inside that limited liability company. So
that's a really great question, and also a lot of investors ask the same question as well. And Angela want to ask that for husband and wife, is it better to do tenant in common or community with survivorship in terms of taxes? Also, strangers do own property together. What type of title is best?
Yeah. So, Angela, my answer to that would be both of those different types of ownership interest tell me that you're holding property outside of your living trust. So my answer would be, we want to see your property inside your living trust. If it's property where you and your spouse each have a separate ownership interest that is using your separate assets, maybe assets that you owned prior to the marriage or assets that you received by inheritance during the marriage, then tenancy in common would be the right approach initially, and you would deed your part into a separate trust you create, and your spouse would deed the spouse's part into a separate trust he would create. If you, in fact, own the asset together as an asset of your marriage, then more commonly it would be held either in joint tenancy or in community property with right of survivorship prior to creating your trust. And then once you've created your living trust as a couple, you would just transfer it into the trust and hold it directly there. There's no difference in terms of taxes, like income taxes, for those two approaches while you're both living. There is a difference in terms of the income tax result when one spouse dies. So here's an example. Imagine you have a property that you and your husband buy, and it has you purchase it for $500,000. You hold it for a period of time, and it's now worth $1 million. So we have $5,000 of gain, or $500,000 of gain built in. And if you are holding that property in as a tenancy in common, when your husband dies, he will be treated as the owner of one half of the property, and that one half of the property will receive a basis adjustment. But you are still alive, and you're the owner of the other half of the property, and you will not receive a basis adjustment. So if you sold following your husband's death, there would be $500,000 of gain, or $250,000 of gain on the portion that you still own. And so you're ending up with only a portion of the income taxes receiving a basis adjustment at the time of the first death. In contrast, if you own an asset as your community property and one spouse dies, the entire property, not just the deceased spouse's half, but the entire property receives a basis adjustment to its fair market value. So
That's
it
huge.
is, yeah, exactly. So it's, you know, in day-to-day terms, it doesn't make a tax difference while you're both living, but at death, it really has a significant impact.
That's great. And she asked also, do
Hmm.
strangers do own property together? What type of the title is best?
So, you know, it depends on what level of stranger you're talking about. But my personal approach, if we're talking about people who are just gathering together for investment purposes, I would want to see that inside an entity. So it would typically be in a limited partnership or an LLC.
Yep. Great question. I know we went over, it's 5:19 right now, just because we have so much great information here. I mean, really how you hold title can not only affecting your privacy issue, but also how you get taxed. So this is really great. And if you guys have any further questions, feel free to contact Sarah directly.
Absolutely. So thank you. I was going to mention that, you know, I'm happy to meet with anyone on this presentation for a complimentary consultation to talk about your particular estate planning needs or your questions that, you know, that we didn't have time to get to today. I'm going to go ahead and place the email address for our client services coordinator in the chat. And you can just simply email her, mention that that you attended today's presentation, and she'll go ahead and arrange a time for us to meet.
That sounds great. Well, thank you so much, everybody, for attending our August webinar. I hope that you learned a lot, and I'll see you next month. Bye.